A lot of disturbance from you, Steven. Hi, this is Rahul Reddy. We are live here from Houston, Texas. Every Tuesday, we do bring in immigration updates. Along with me is my business partner, Emily Newman. We also have Stephen Brown. We may have some disturbance coming from his live because he just is on the way back from the court litigation from Washington, D.C. He's in the airport. So you may hear some disturbance from him. Please excuse us for that. Emily, in the SEVIS system, as we know, that things have been reversed. Now, almost everybody has been put back into the SEVIS system. That means that they can go to school, they can graduate, at least what it has been said. And they can, if they have an OPT and STEM extension, they can work. Now, this is based on the old policy that the policy was that when the visa has been terminated, it doesn't terminate the status of the person. They are still in status. Based on that, I don't know why they terminated them. Of course, with the court cases, they put them back. We all know for sure that the government doesn't want to continue like this. They want to terminate the SEVIS system. They want to terminate the legal status for all these people again. Of course, because of the court things, they did backed off. Now, what do you, Stephen, any updates on the court, Stephen? What's going on?
Yeah, so we had a hearing today in D.C. in one of our individual cases. We had a preliminary injunction hearing, and Andre Watson, who is a senior level position with ICE, was discussing what happened to get to this point and a new policy developed by ICE that's dated as of Saturday and filed in the record. I put it up on Twitter, and happy to kind of take it from there if you want.
So what practically they are telling is that they changed their policy that if the visa has been revoked by the consulate, they will terminate the SEVIS system. Is that how you read it, Emily?
Yeah, so it seems to be that they did all of these things without having a plan in place, without actually having any policy or regulation or statute that allows them to do that. So that's, of course, why we brought them to court in many different cases, lots of lawyers across the country. And so they said, well, hold on, while this case is in process, we will put everybody back in status, turn their SEVIS back on, because we're getting ready to now announce a policy. And so we have that policy, and basically all it does is add a line to their existing policy that now says that they can terminate SEVIS records for a variety of reasons, which we already knew, but they've added the fact that the Department of State has revoked a visa as one of the reasons that they can terminate the SEVIS record. Basically, they're claiming that because having a revoked visa is something that makes someone removable from this country, that they can use that now as a reason to terminate the SEVIS record. So that is their new policy, even though they've put everybody back in status. My guess is under this new policy, they're going to turn right back around and put people out of status in accordance with their new policy. I don't know, Stephen, if you have any differing opinions on what they're going to do with this policy. Has it actually been published? I mean, it says it's to all SEVP personnel. Have they received it yet?
So a couple of thoughts on that. One, it's my understanding they sent this to SEVP personnel, which would be ICE officials. I do not believe they sent this out to DSOs. In fact, I emailed one from the plane asking her if she had seen it, and she had not. I think what makes this policy interesting is it's almost an own goal by the government. We have been arguing that the non-policy they had in place was ultra vires. That means no authority to do this. And this is even more ultra vires, even more without authority. it goes against at least 15 years of ICE policy without any recognition of that previous policy. And it goes against, I don't know, decades of Department of State viewpoints of prudential visa revocations not impacting status. So I can tell you, I actually just saw on the plane a court order out of one of the ACLU cases, even from today, even though the policy is now out. I don't think this changes much of our litigation strategy, other than we're going to now say that the new policy is ultra vires. So I think that's what they want to do, is to go back in. But I'll note, even if it's their position that the revoked visa makes them amenable to removal proceedings, which is true under the INA, although never really happens when people are actually still in status outside of extreme situations. Um, they should still be able to be in status until they initiate removal proceedings. And that's, I don't understand how they think, oh, we could just do this anyway. So again, I think we're certainly not back at square one. We're just kind of back going in circles here, because I don't think it's changed much.
Can
Yeah,
you
so they're really trying to do everything backwards. So if they're claiming that because the State Department has the discretion to revoke a visa, and revoking a visa can allow them to be put into removal proceedings, they're just skipping the removal proceedings and going straight to, we're putting you out of status. Well, that's the whole point of removal proceedings, is to have the due process, to have a court that looks at the evidence and decides whether this person is removable or not. Because the types of arrests, the parking violations, the people who are not actually convicted of anything, the people who are the victims of a crime, they're not removable under any of the criminal grounds that can make someone removable from the United States. And so they're just doing everything backwards without anything. And then I really like, in this policy, they have a disclaimer at the bottom that it says that this message is not a substitute for applicable legal requirements. It's not a rule, it's not a final action, and it's not intended to, and that may not be relied upon to create any right or benefit or enforceable. So they're basically saying, we're putting this message out there, this is the policy, but it's not really anything important enough to require Administrative Procedure Act, where they have to go through notice and comment rulemaking.
So, Emily and Stephen, what practically you guys are telling is that even though the people whose SEVIS has been terminated, almost all of them were being put back into SEVIS system, now they have they're at least creating an authority for themselves to terminate the SEVIS system again.
Exactly.
So in other words, we may have to fight this in the court again then.
Well, we're still in our lawsuits that we have right now. I mean, we're not even 30 days into this. So we are preparing to put this into the current scope that we have. In fact, we replied to a status report today and put this policy in front of the judge and said, this is still ultra vires, this is still problematic, this is still irreparable harm. And so I think it doesn't, I keep saying, there were people saying, oh, this is a win, they're putting people back into status, and I absolutely agree. It gives us a breath of fresh air. This is what we wanted with TROs and injunctions, but this is a tactical retreat and allowing them to regroup rather than a full resolution. And I'll note, one of the things they note on that policy is they can terminate SEVIS any instance of failing to maintain status, which is, true. But all of these issues with regards to these actions by ICE, all of them came with a termination of SEVIS for otherwise failing to maintain status, individual identified in a criminal records check. Now, they keep trying to argue that that's not a determination that they failed to maintain status. I guess it just magicked itself um, into the record. But I think a determination that they failed to maintain status is a determination they failed to maintain status, and I don't know how to read it any other way.
Yeah, and in this new policy, ICE even says that if we are terminating a record because we think someone is no longer complying with their non-immigrant status, they're supposed to enter information into the record that actually identifies the failure to comply. So they can't just say you are failing to maintain status or you failed to comply. They're supposed to enter the information that explains what that failure is. And I don't think that's been in anyone's SEVIS terminations up to this point. So we'll have to see if in this new round of terminations that we anticipate coming, if they're going to have more information about what the supposed failure to comply with the non-immigrant status is. Are they going to use this criminal records check as the basis of a failure to comply? Because the criminal record itself does not impact anyone's status. It doesn't mean they're failing to comply. It just means they had a run-in with law enforcement. Could have been the victim of the crime, could have been parking violation, could have been lots of things that don't make anyone removable or inadmissible, even if they had. And a lot of them, as we pointed out before, the charges were dismissed or dropped, or they never got convicted. So if you're not actually convicted of a crime, you're not removable under any of the criminal grounds. There has to be a conviction.
At this point of time, I would recommend all the peoples whose service has been terminated and later on were being put back into the system, be an alert. Try to make sure that you do not travel, even though your service has been put back because your visa is already revoked. If by any chance you did not get the email from the consulate, don't trust it. Don't travel at this point of time. Keep checking your service record. Also, make sure you stay enrolled in the classes, attend the classes, and if you're OPT and STEM extension, you continue working because otherwise you will have been violating the status. And when, if there is anything occurs, though, please, there are some people whose service has been terminated. I don't know who advised them, but they just left the country. And right now, even though their service has been reinstated or put back into the system, they cannot come back now because their visa has been revoked. We have been advising people to file the court case. We told people to not take an immediate action. Let's see what goes on. There are some people who scared them, saying that, hi, ICE is coming and arresting, which they didn't arrest any of these people. And some of the people left. For them, even though their service has been put back, unfortunately, they cannot just travel back. They have to apply for the visa stamping in the consulates, and we don't know how the consulate is going to behave, and there may be problems for that. So don't get a knee-jerk reaction. I know at that point of time our appointments were blocked up, but please follow our YouTube channel and go back and see what we have told and what happened right now. Don't immediately pack your bags and go. Just make sure that you're doing the right thing before you do. Beware of the social media. I mean, not everything that comes out may be true. So please be watchful. What is rightful, what is not rightful. Any other suggestions for these people, Emily?
Yeah, I think the best thing is just to not panic, but also be aware that the story's not over. More is likely to come. We do expect ICE to take additional actions in terms of the SEVIS records. And so just monitor that, be in close contact with the school. As Raul said, make sure you're maintaining your status, not doing anything that's going to violate your status, definitely. Avoid interactions with law enforcement, follow all the laws, but just don't take any knee-jerk reaction. if your SEVIS record gets terminated again, because all of these cases are still in litigation, even though they turned the SEVIS records back on, because we need to actually get to the merits of the case. We haven't gotten to the merits in any of these cases. The only hearings that have been going on so far are whether a temporary restraining order is needed or whether a preliminary injunction is needed. That's the only arguing we've been doing so far. And so ICE's whole way to get around these injunctions and temporary restraining orders is to turn everybody's record back on and say, well, we're developing a policy and we'll get back to you. Well, now we have this policy. We can see exactly what their playbook is. And it's to basically give themselves permission now to do the things that they were doing before, because before they didn't have a policy in place. So we still have to get to the merits of the case with this new policy. So hopefully we will continue that fight and get actual decisions from courts confirming that the actions ICE is taking are not lawful and that they need to keep everyone's SEVIS record active, at least when it comes to visa revocations.
Couple of things. We also want to warn people that the government is putting a lot of misinformation. When the visa has been terminated for all the SEVIS people, they told that they are informing the Immigration Customs Enforcement, Department of Homeland Security. They have given how to self-deport. All that was a scary thing that they did it. They are continuously doing in other sense also. They put a G325R where they said everybody who is in the United States in the past 30 days, if you are for more than 30 days, you have to file this G325. But that is the biggest, one of the other biggest lies that the government is trying to scare tactics just to intimidate the people, though. There are three parts of the government, guys. One is legislature, which is parliament. The second one is executive, which is the Trump administration. The third one is court system. So if you get intimidated by one, though, we still have other two parts of the government that we can go and get it solved, especially the G25R. It says clearly everybody who is in the country for more than 30 days have to register, but that's not true, especially for the legal immigrants. Very 1% of them need to register. For 99% don't have to register. It's a scary tactic. Now, Emily, they came out with another one today with the USCIS Twitter account that says green card are a privilege. It's not a right. Practically implying in the USCIS Twitter that, hey, it's like when you come as a guest to my home, you have to abide my rules. For example, if my wife says that you cannot bring any non-vegetarian to my home, you can't. I mean, that's a privilege, is right, for anybody to come into my home. The way that they are sounding this one is that it's just you are a guest, you do not have any rights as a green card holders. It's not a privilege. You do not have a right. Visas are a privilege. Not You do not have a right to stay in the country. That's how they're implying. I will read it. Green cards are a privilege, not a right. That's exactly the word they put it on the Twitter. They are intimidating it. Don't buy into that right now. These things can be fought, they have to be taken with a pinch of salt. So don't get intimidated. Any advice for them, Emily?
Yeah, I mean, obviously they're trying to say that Big Brother is watching them and they're reviewing social media and using AI to try to find people that are against national security or are foreign interests and that sort of thing. I don't think that means that they can censor free speech and that you cannot criticize the American government or the Trump administration. I think they're focusing on other issues, but they're definitely using fear to try to get people to leave on their own, and try to get people to not come into the US, which is very short-sighted, based on the tourist dollars that come into this country. We're already seeing so many people choosing not to come to the US. Next, it's going to be F-1 student enrollment is going to go way down. We're going to lose out on global talent. We're going to lose out on the economy, tax dollars, so many things that are so short-sighted just to create fear and try to get people to leave.
Emily, going to the third topic, there has been an increased site visit, as you know, that there is an FDNS visits, the new regulations that came out in January 16th of 2025. That was while Biden was in the Biden administration. That made that cooperating with FDNS as a compulsory. If not, your H-1B will be revoked, or in cases it will be denied if it's not already approved. So Emily, explain more that what's the difference between FDNS before January of 2025 and after January of 2025?
Yeah, so before January of 2025, an employer or the employee who are the subject of the site visit could say, you know what, this is a voluntary program. I don't have to participate in it. And USCIS or the FDNS officer would take that information and just say, employer or employee did not participate in the site visit. And then USCIS has to make a decision from that. They can't take any negative action. They can't deny a petition because you didn't participate. They can't revoke an approved petition because you didn't participate. That's all changed as of January. You're required to participate in that process. And if you choose not to, they can deny your petition if you have one pending, just for the fact that you have decided not to participate in the site visit. Or if they're coming for a petition that's already approved, they can go back and revoke that approved petition. They have to go through the notice of intent to revoke process. So they have to send a notice first, but they can do that simply because you chose not to participate. So for that reason, it is mandatory for the employer and the employee to participate in a site visit. That being said, they're still asking a lot of questions and asking for a lot of documents that are really just a fishing expedition that have nothing to do with the petition itself, the validity of the petition, verifying the details of the petition. So you still have to be careful about what information you're going to provide, what you're willing to answer, and make sure it's actually relevant to the petition itself, because we're still seeing that people are oversharing information, and that can lead to a notice of intent to revoke.
We're also noticing audits for the STEM people who are working on STEM OPT. And they are auditing the employers who are employing the people who are in STEM. As you already know, that STEM OPT requires that the company must have been a E-verified company. They must also be employed and have to be paid. It's not like OPT where a voluntary employment is allowed. We're having some audits coming on STEM OPT. I would not say it is coming to a greater extent, but we're seeing more and more on the STEM OPT. If by any chance you think so that you are not getting paid on STEM OPT, you may be in violation on the STEM OPT though. And also there are other things that you need to follow. Are you working in the similar field that for which you graduated on? Are you documenting what is required by the 983? All those things need to be taken care of. Otherwise, your STEM OPT may be revoked and you may be suspended. You may be terminated from the SEVIS system.
Yeah, with that, so the STEM OPT site visit, they're basically wanting to verify that the company has sufficient resources and supervisors to actually run the STEM OPT training program. So they may ask questions of who is actually overseeing all of the students, how often do you check in with them, how are their assignments provided, what is the background of the person who's providing the training? Are they qualified to provide the training? They might look into the company's recruitment process, because as part of it, the STEM OPT program requires the company to provide similar duties, hours, compensation, and benefits that are commensurate with the terms and conditions that they provide to U.S. workers. So they may ask, how did you find this job? What websites does the company use to recruit? Does the compensation differ between US workers and STEM workers. And then they might talk to the student and verify what degree they had that's the STEM degree, confirm what their job duties are. How does those job duties relate to the classes that they took? How often are you in contact with your DSO? And then just verifying dates of employment to make sure that you're not exceeding the unemployment limit.
Stephen, this policy, what you're speaking about, I know the answer, but I just want the answer from you. This question is coming from Shiv Shankar Yadav, whether this ICE policy is going to be retroactive or only going forward.
I don't even think ICE has an answer to that. I mean, I think it'll be going forward. They're going to do this, but if the visa's been revoked, they're viewing that they have authority to terminate SEVIS because you're removed again. That goes against a decade and a half at least SEVP policy. So I don't, Frank, think
So
this
practical,
policy is going to last long.
If my visa has been revoked on April 2nd, based on the ICE new policy, if they follow that, would they terminate me on May 1st week from the SEVIS?
I think that they view that they have the authority to do that.
Yeah, in their policy itself, it says that if the Department of State revokes a visa effective immediately, then SEVP may terminate the SEVIS record based on that visa revocation with immediate effect. So that seems like they're pointing out how all of these things can happen immediately, and therefore planning to take steps going forward. I don't know if they're going to actually review these criminal records to see if maybe they went a little too far in who they are revoking the visas of and who they're planning to terminate the SEVIS record of. I would hope there's some sort of looking into it, but based on some of the discovery that's going on, some of the email communications, it looks like whoever made this decision basically said, okay, thanks for doing this project, finding us all these names. Terminate everyone's status, all of them effective immediately, is what the email notification said. So they don't seem to be going through any kind of process other than just putting names together and then taking action on everybody.
Question is coming from Rahul and from YouTube. Are we guys considering for a lawsuit for new clients for lawsuit right now? Yes, I would say right now there is, everybody's SEVIS is being put back. So the cases that we filed, of course, Stephen is going to continue with them. What about the future things, Stephen? If they terminate again, what do you intend to do?
Our ultimate goal, and again, I'm sorry, everybody, I'm trying to get out of the airport here. Our ultimate goal is that there are certain regulations with SEVIS, there are certain statutory grounds with SEVIS, and all of these policies and determinations violate that. And their voluntary cessation of putting everybody back doesn't stop the lawsuits. We go forward. We add a little new spice to it with this memo. But I truly think that by the end of this endeavor, whether whether it's us or the hundreds of other litigators litigating this, this policy memo is going to be invalidated too.
Let's go to questions, Emily. Question is coming for the I-140 biometric requirement. Why are they asking it? We have, there are cases where they're asking for biometric requirement. I definitely want you guys to consult an immigration lawyer before you just walk into the biometrics, though. There is a question from Balakrishna. His daughter filed a G325, and now they are inviting her to do the biometrics. You can take your daughter to the biometrics. We are not expecting any problem for you there. As long as she's in the legal status, we are not expecting any problem for her at all.
Yeah, a couple of people had asked what's the latest update on those requests for evidence for I-140s and I-129s, where they're asking for the beneficiary address for biometrics because of some derogatory information that's in the beneficiary's record. So in one of our first cases where we saw that request, we replied back explaining all the reasons why biometrics have nothing to do with an I-140 approval. I mean, what were they expecting the people to do? Because an I-140 can be filed for someone who's not in the US. So what would they plan to do for someone who's not even in the US with their biometrics? But anyways, we made a lot of arguments with that. They actually went back and rescinded that RFE and then issued another RFE that simply says, we're sending you a biometrics notice. Once you complete your biometrics, please respond back to this RFE. And we have until July or something. We have not received the actual biometrics notice yet. And it's interesting in that particular case, the individual, it was an I-140 petition that was also filed with a 485. They had their biometrics done with the 485. Why on earth are they asking for them again for an I-140? It's just ridiculousness, and the left hand doesn't know what the right hand's doing. So we'll see what happens once we actually get the biometrics notice and have half a mind to respond back saying, here's the biometrics you sent for the 485 that's already been completed. Go ahead and look at that. But it's definitely going to be a continuing process just to see what USCIS does with these for I-129s and I-140s.
Emily and Stephen, I have this question though. Right now, we see the new policy internal memo that's passed, and according to that, it seems that ICE is going to interpret that, Immigration Customs Enforcement is going to interpret that if the visa has been terminated. And visa can be terminated for a lot of different things. For example, if they get any derogatory information, like anybody, anytime, even if they are not being proven guilty, for example, even an arrest for something, even later on, it's been decided that the prosecution completely drops. It's a false allegation that has been, their visa gets terminated. That means that when they go outside the country, they have to get visa. And now they're telling that they may terminate the SEVIS right now. They did terminate it, they put them back. Now they're telling that they may terminate again. What about for those people who are on H1B, non-immigrant visas, other than F1s? They're not even in the SEVIS system. They are on H1B. Would they do the same thing?
I mean, I think they would have to go through a different process, a notice of intent to revoke, and all of that. I think they're saying they can do this because this is wholly an ICE realm, and there's a lot less of due process in their mind. And again, remember, all of this is an interplay of they don't believe SEVIS is necessary for status, that you can be in status without a SEVIS, which is complete baloney. It'd be like saying, hey, we revoked your license, but nobody said you can't drive. So again, I hate to beat the same drum, but I don't think ICE has any clue what they're talking about here. I will say this: a week and a half ago, we got a declaration from the same guy that was in court today, saying that a prudential visa revocation, absent other factors, does not make an individual amenable to removal proceedings. And now ICE is saying, huh, anytime a visa is revoked, this is what has to happen. So I don't think they know what's going on.
With the fear hanging around, people like Nikhil Kumar from Twitter and Rahul M from YouTube is asking the question, would you, because now their fear, of course, based on the new policy, seems to be that they may terminate the SEVIS system again. Can we file a lawsuit even if they are being put back into SEVIS system right now, or should we wait until this SEVIS system is terminated to file a lawsuit for them?
I'd have to think through that. I mean, I'll tell you, our hearing today The judge grilled ICE for probably about 45 minutes, asked if we had anything, and she said, I don't know what I can give you today. They tell us everything is fine, everything's good, he's in status, all that. What can I give you? And we started talking about ultra vires. She said, no, everybody agrees that it's ultra vires, that it's arbitrary and capricious, but he's in status. What do we want? And then she told us to reach an agreement. And she said, I'm going to give everybody a week to figure this out because ICE really, 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 really does not want me to enter an order. So I think there's a question for those that aren't in litigation about the harm, but I also know there's arguments that I've thought through on the flight today because, again, at its core, that policy is arbitrary and capricious, and you could challenge that policy.
So
Again, super,
we're having some disturbance from Stephen, though. Well, what
for
practically
practical,
he's telling.
I think you can.
Go, Stephen. We're having some disturbance from Stephen. What practically he's telling for Nikhil and Rahul here, who wants to file a lawsuit, is you are already in the SEVIS system right now. Yeah, you're already in the SEVIS system, but of course you have a fear that they will terminate you. But Stephen is going to give an update after he discusses with his team, the litigation team. He's going to give an update. I'm going to have him have a separate session on this alone. Anything else, Emily? We are going to go to questions, Emily.
Yeah, another question about that was, for those that actually did file the lawsuit and their SEVIS has been reactivated, should they dismiss their case because their SEVIS has been reactivated? And I would say no, it's way too
No.
soon to do that. Definitely not. Stick with it. This is definitely a moving situation where we are expecting additional action from ICE. And so if you dismiss your case because you're fine now, you're not covered when they try their next tactic. And would have to file another lawsuit at that point.
Yeah, I mean, if we agree with the ICE and we dismiss our lawsuit, they will just terminate the civil system next day, and then we're back to square again. If they give an assurance that these clients whom we filed the lawsuit that they will not terminate their civil system because their visa has been revoked by the State Department, and they will not terminate the civil system because of that reason, then that makes sense for us to terminate the litigation. Otherwise, we'll be back to square. Stephen, are you still there? Well, but he's a little bit.
I'm trying to be. I'm trying to be. Am I? Can you hear me?
Yeah, we can. But you're getting cut off in between, though.
Okay. Yeah, sorry about that. I do think it's premature to dismiss litigation. I think, look, the INA has statutory language about removal proceedings when a visa has been revoked. That's been there as long as I can remember. It never gets used for people that are in status because it's dumb, all right? Because they'll not be removed because they have a non-immigrant status unless their visa is removed from a national security reason, a fraud reason, something like that, right? And so, how many times have y'all had a conversation with someone who gets a visa revocation for whatever reason and no issue at all with their H1B, their TN, their L, whatever it might be? So this idea that they're going to terminate the SEVIS, which will put them out of status, that's where I think we could see issues because now you're an undocumented immigrant at that point. You don't have status. Again, always had authority to do these removal proceedings, but they can't really do it when you're in status unless there's extreme circumstances.
For those people whose
Here's a
H1B, go ahead, Emily.
I was going to say, here's a question for you, Stephen. With those students that have been reinstated and were selected in the H-1B lottery, should they go ahead and file the H-1B now, or should they wait? Is there any benefit to waiting?
OPT, STEM OPT, H1B, file it now. While you're in, I can tell you, we had a hearing Thursday where we pointed out there was one notice of intent to deny that was going around on an H1B that was saying on the status, not the underlying H1B. It's two parts of the adjudication, and it said, well, your SEVIS has been terminated. You're not in status, so you can't change status. And we brought that up to the judge, and the government attorney, I guess he's now a former government attorney, told.
Why is that? Why is that he's a former government attorney?
Well, I'm sorry. He's there for 2 more weeks as he works his way out of the government on his own choice to go into private practice. The government told the judge that they spoke with OIL, which is the Office of Immigration Litigation for the Department of Justice. OIL spoke with USCIS, and they concluded that that RFE was legally deficient, meaning it was a bad RFE. So, if you get these RFEs about, hey, your SEVIS was terminated, email them to us because I'm going to load those up in our court cases, redact everything, so you're not identified. But again, I would file immediately if you can, if you were hit by this. File for your OPT, file for your STEM OPT as soon as you can, and get that, get those documents and get on the H1 or whatever you're going to get on. If you could, I talked to somebody who qualifies for a green card because they got married now to a U.S. citizen they met in college. Great, file that adjustment of status right now, and just don't worry about it anymore.
And for those people who are in this status, if you're filing H1B, do in premium processing, guys. Because there are more court hearings that are coming. We don't know how the SEVIS is going to behave, ICE is going to behave. Please, file in premium processing, get it. If there is any RFE, it's better we can resolve it right now rather than do it later on.
Here's a non-F1 question. This comes from Ajinkya, and it's a very common misinterpretation that I think people have, and I'm not quite sure where it comes from. But he says, during the change of status filings, does the new status take effect upon approval, or does it start from the date of filing? For example, an H1 to H4 change of status. Now, I get a ton of consultations from people on filing a change of status to H1 from H1 to H4 due to termination of employment or something like that, a layoff situation. But sometimes it's from people who are nearing their 6-year limit and their perm is in process but won't hit 365 days. And they're thinking about what to do well in advance. And so for some reason, they think they've been told that simply because they have filed the H4 change of status means they have to immediately stop working on the H1B. Now, that would be true if your H1B was expiring, or if you were at the end of your 60-day grace period, or the company was going to withdraw your approved H1B. But let's say you have an H1B that's valid till December 2025, and you're still working for that company, nothing's wrong with your job, and you just want to switch to H4, and you want to file it now because you know it takes 6 to 8 months to process. You can file that H4 change of status now and request an effective start date that's 6 months from now while your H1B is still in effect. And while that's pending, you're still in H1B status. Yes, you can keep working. No issue with that. So no, it doesn't take effect from the date of filing because it's not approved yet. So filing something doesn't change your status. Filing something keeps you in a period of authorized stay, meaning you're lawfully present in case you're losing your status, but it doesn't change your status just by filing it. So no, it does not take effect once it's filed. Now, if your H1 is expiring tomorrow and you file a change of status to H4 tomorrow, you can act as if it takes effect from tomorrow, be as if you're in H4 status because you can't work anymore because your H1 is expiring, but you're not in H4 status yet either. So you're in a period of authorized stay and cannot work in that situation.
I'm having a lot of problems with the global entry people who are on non-immigrant visas, especially if you have the visa stamping not appropriately. For example, you have a H-1B visa stamping with company A. Now you're working with company B. You're entering in global entry, not a good thing at all. Go through the officer and make sure that you get the proper I-94. And if you have H4 stamping until 2025 September, and your spouse H1B is already extended until 2028, and you can use the spouse H1B to get an I-94 until 2028, that cannot be achieved in global entry. So at this point of time, we want to maintain a lot of caution on the people who are using global entry who are on non-immigrant visas. So definitely don't, it's just because it's easy, don't use it because that's going to create a problem. The I-94 may reflect a wrong date, and sometimes you will go out of status or even unlawful status because of the global entry. So we advise people with a lot of caution. One other thing I tell everybody is that when you enter into United States, please check the I-94 online. You go to CBP website, you check the online I-94 because if there is anything wrong, it's easy to correct before the I-94 expires. If they may do a mistake, they may give an I-94 because your passport is expiring. Let's say your passport visa is expiring in 2026, but your passport is expiring in December 2025. They will only give an I-94 until December 2025. So don't check in January or February of 2026 and go to the lawyer. Check it immediately. That's the common mistake that we see every single day. I get one consultation because of this. Please avoid that one. Check the I-94 online immediately.
Babu says, I'm on my grace period on H1B after a layoff and I'm about to get an offer. Can I begin working as soon as my new employer files the petition, or do I need to wait for petition approval? As long as the H1B transfer is filed while you're still in your grace period, you can start working as soon as that petition is properly filed with USCIS. The AC-21 H1B portability still applies. You don't have to wait for the petition approval to begin work.
Question from Venkat Kumar. Is it safe to travel to India to go for visa stamping right now? The answer is no, 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 no. It's 13 times no, guys. Just want to make sure. No, absolutely not right now. Yeah, if your dad has a Ferrari car ready for you and a big villa there ready for you, and if you don't get the visa stamping, you're willing to take that Ferrari car and that big villa from your dad, that's up to you. But we are facing a lot of problems there for visa stamping. People are asking me a question. Well, can I send my wife there because I am working? Well, if you want to get a new wife, that probably is a better way of doing it. Uh, but definitely, I suggest not even H4 right now. A lot of problems we're facing in the 221G. You need to understand that this administration doesn't like immigrants. They don't like to give non-immigrant visas. They don't like to give the green cards. They don't want the people who are here on non-immigrant visas. They don't even like the people who have a green cards right now. That's how the things are. So we are fighting back. So you need some cooperation. It may take a little bit time. Even when the last administration came in, the Trump administration I'm speaking about, it took a while for us to figure it out how to do, what to do the things. Especially court systems helped us a lot at that point of time. We are working on the court system, but you want to be the scapegoat for it? It's up to you guys. I mean, we don't want you.
Uh, I'll
Maybe the
get.
persons who go ahead.
I'll give you one caveat though, Rahul. I mean, we did a 212 waiver approved for someone who was deemed inadmissible by the Biden administration. It was a complete mess job by CBP, and she got the 5-year bar, and we worked probably a little over a year on this, and she's back home and back with her family now, and I'm real happy about that. So those are very tough cases because of the discretion, but
Well,
a bunch of those cases.
yeah, so if you go there, you get stuck there. We are there to fight, but do you want to do that? If I were you, I would not like to hire an immigration lawyer. I would like to play safe. So they are trying to restrict. Yes, you can hire Stephen Brown, you can hire Emily, you can hire me and pay us a lot of money. And sometimes we are victorious, sometimes we are not. But either way, we make money, guys. I'm sorry to say, but we make money. So if you can avoid that, we really appreciate that.
Yeah, I don't
Arendam says, I
want to
applied
do a
for,
bunch of those cases.
I'm sorry,
um,
Emily, you're saying something?
yeah, Arendam applied for a change of status to H4 after the SEVIS termination. Now his SEVIS record is back and wants to know if the H4 change of status application is still valid since I'm back in status, and if the 90 days of unemployment OPT time is over. So just because your SEVIS record is back, it doesn't have any impact on the pending H4 change of status. So you can let it continue to be processed and get approved. Once it's approved, you're back on H4. Or if you feel comfortable with your F1 status, you could withdraw the pending H4 and continue in your F1 status. But if you don't withdraw the H4 and it gets approved, it's much more difficult to get back into F1 status. You can't just withdraw it. You have to file a change of status at that point. As far as the unemployment time, I mean, you are still in F1 status if your SEVIS record has been reinstated, which means if you're on OPT, you can go back to work. So you shouldn't be accruing any additional unemployment time.
A question, if this question, Emily and Stephen, I probably need an input on it. If the FDNS come to my workplace and they're asking about my previous workplace, am I under obligation to answer the question? Questions coming from Manasa.
That's a good question. I mean, I think I would ask to have them speak to my attorney, and I would tell them I don't think it's relevant. I'm not with that company anymore, and let the attorney take it from there.
My I-94 is expired and I have the advance parole in active. Will I have any travel on the advance parole? We are not seeing any problems with the people who are having an advance parole to travel. We have not seen not a single case at all. Unless they have some major criminal records that we don't know about, we haven't seen any problem to anybody.
Atik has another question that people get confused on and get wrong all the time. So he's currently working on his initial OPT. The company at the time he was hired was not an EVerify company, but they're going to join EVerify now, and so that he can file for his STEM OPT. And he wants to know, does the company have to create the EVerify case for me in order to file the STEM extension since I was already employed with them? No, they do not. EVerify, once the company is in EVerify, they only use it for new hires going forward. They don't go back and verify anyone that they've already hired. And they're not required to EVerify you because at the time you were hired, they were not an EVerify company. I see a lot of companies getting that wrong and willy-nilly E-verifying people because they think they need to have that proof that you've used E-verify for this person and have that case, and that somehow USCIS has access to whether this person is E-verified or not. That's not how it works. E-verify is a completely separate system. The whole purpose of E-verify is for the company to complete the I-9 process to verify that the people that they are hiring are authorized to work and they are who they say they are, their identity documents. That's it. Has nothing to do with your status. The only thing you need to prove when you're filing your STEM OPT is that the company is an E-verify company. They've created the account, they've signed the memorandum of understanding, and they're in good standing because they're using the E-verify system. That doesn't mean they have to use it for you in order for you to file your STEM OPT extension.
This question is coming from TD. Since you're generally not recommending to travel to go for H1B stamping, is it safer to switch to GCEAD and travel? Here's the thing, though. if you have an advance parole and you have an H-1B, I strongly recommend you don't go for H-1B stamping. Please come back on advance parole. It's not EAD that will allow you to travel back. It's the advance parole that will allow you to travel back. You can travel on advance parole. I've been telling you can travel on advance parole. Now, a lot of people ask the question, if I travel on advance parole, will my H-1B will become invalid? The answer is no. It is still active. You can extend it. You can amend it. You can change the employer. Absolutely not a problem. So you can travel on advanced parole and still after coming back, extend the H-1B, transfer the H-1B, or amend the H-1B.
HK says, if we file the H-1B now, dealing with the SEVIS termination issue, and it gets approved, but it doesn't start until October 1st. That means I'll be on OPT and F-1 up until October 1st. What happens if ICE terminates the SEVIS again after the H-1B is approved, but before October 1st? Yeah, that is a risk, and that is what litigation is going to be dealing with for sure. Because yeah, although you've got the H-1B approved, it doesn't actually take effect until October 1st. So you are continuing your F-1 status until that time. But if they do revoke or terminate the SEVIS record under this new policy, we're hopeful that new litigation will solve that.
If I file the adjustment of status in family-based and later on I get my SEVIS terminated, what is the consequences of it? Well, you're supposed to be only in legal status until you file the 485 application. So after that, adjustment of status is a status. So you are out of SEVIS. If you're terminated from SEVIS system, you can move on to the adjustment of status. So that's one safety that you have, especially. So I don't see a problem for you if you file the 485 application pending, and after that they terminate the SEVIS system, then you're fine. I don't see a problem for you. Do you need to carry all the documents every time you go everywhere? We have not noticed people coming and picking up the people because they don't have documents with them. Definitely driving licenses where I tell everybody to keep it with them at all times of time at all times. But is it necessary to keep the H-1B original document, EAD, all those things? I don't recommend. If you want, you can keep a copy of them with you, but not necessarily the original documents of everything. You don't need to carry it everywhere. We haven't seen that kind of thing yet. And when there is anything like that, we will inform you. Anything else, Amrit?
Oh, I guess we are out of time for today. Thank you everyone for joining us. We hope you find this information helpful as we deal with all of these uncertain times with the Trump administration and ICE and all of the different actions that they're taking. Hopefully we're not fear mongering and scaring you too much and just providing the real information so that you can make informed decisions about how to proceed with your immigration future. Please subscribe to our newsletter by going to rnlawgroup.com. So you'll get the updates every week. We send out articles of what is the latest going on with immigration and go into more deep dive.
Just before we close in, Emily, then fear mongering and all those things. When the CVs has been terminated, though, we clearly said that ICE is not coming and picking up. We have taken the path of court litigation. We have not taken the path of reinstatement. We have been in business from 1997. That's 28 years we're in business. And we have old people like me, and we have young people like Stephen Brown, who is more into litigation. And of course, our managing partner is right in between me and Stephen Brown, Emily Neumann. So we have all kinds of people with us in our office. We've been in business for 28 years. Please tune in. Previously, immigration authorities used to give out clear information. Right now, we cannot even trust the government resources. And there are some people who said, oh, people are picking up all these SEVIS terminated people and then throwing outside the country. That turned out to be not true at all. So please, you need to try to get onto the channels that are giving good and truthful information at all times. And if needed, fight on your behalf. Thank you.